Good morning and welcome to another edition of BCR Webcasting. I'm delighted to be joined today by Professor Sir Roy Goode, who is Emeritus Professor of Law at the University of Oxford. Professor Goode will be speaking at our Receivables Finance Convention, which will take place on the 22nd and 23rd of May in London at the offices of Clifford Chance. Professor Goode is one of the most influential commercial scholars of the last 50 years and is the author of many widely used leading textbooks on the subject, and is widely considered to be the leading authority on assignment. Professor Goode, welcome. The particular session that'll be covered next month at our RFIx convention is going to be focused on the law applicable to the cross-border assignment of claims, and we'll look at both factoring and securitization. So we just have a few minutes today, and next month at RFIx you'll have a whole hour to cover this, but maybe you could give our audience just a flavour of what is going to be covered then. I mean, what sort of legal problems might arise from an assignment of claims involving a foreign element?
As a whole cluster of claims, the subject, in fact, is quite complex, but it's very fascinating, at any rate for lawyers and even for some non-lawyers, I think. Typically, what is set up when you have an assignment of a claim is a cluster of different relationships. So you've got the relationships between the creditor and the debtor, between the creditor and the assignee, between the assignee and the debtor. Then you have questions of what happens if the assignor becomes bankrupt. You have trustee in bankruptcy coming in. Is the trustee to be treated as a third party or not? Then you have competing claims between the assignee and, for example, an attachment creditor who's seeking to attach the assigned debt for something owed to that person. And then you have the general impact of insolvency. So there's a whole cluster of problems, and each of these relationships may be governed by a distinct law. You have to work out what law applies. Some of it is quite straightforward, but some issues are complex and indeed quite controversial. That's why they're fun to discuss.
And our audience in our next month will largely be practitioners and people who are familiar with factoring and securitization, but maybe not all. So could you briefly just describe what are the principal types of transactions in which these problems can arise?
Well, factoring involves typically the assignment of receivables from a supplier to a factoring company, and the traditional way of doing it, the old style factoring, was notice of the assignment of the transfer to the buyer to the factor would be given to the customers, the debtors, the underlying debtors, and then the factor would collect. Well, that gave way quite a long time ago to non-notification factoring, where the supplier does not notify the customers. This is in order to preserve the relationship between the supplier and the customers, and instead collects on behalf of the factors, paid by the factor for the value of the receivables, less a charge, and then collects and transfers the money to the factor. That's non-notification factoring. There are all sorts of variants on that I needn't go into. Then securitization really involves converting non-tradable assets, or assets that are not available on the market, into tradable assets by pooling them, transferring them to a special purpose vehicle, which is bankruptcy remote, others protected against the likely consequences of insolvency, and then the SPV issues bonds or notes on the market against the security of the receivables. So you get investment coming in to support the whole enterprise. Thereby you convert what is not tradable into tradable assets. That's a very, very simplified version.
And there have been attempts, haven't there, to harmonise laws to try and make things a bit easier in terms of resolving legal issues. Can you just describe that briefly for us, please?
Yes. There are two types of harmonisation. One is to harmonise the substantive law. For example, on factoring, you might try and harmonise the actual rules governing factoring as opposed to merely choice of law. That was attempted by Unidrar many years ago with a convention on international factoring. It is actually technically enforced, but it's not really been supported. There's enough to bring it into force, but it's not really taken off. Then you have attempts, say, if people feel they can't harmonise the substantive law, well, let's try something more modest and try to harmonise the conflict of laws ruling. Harmonise the rules governing what law applies. And there we have the United Nations Convention on assignment of international trade debts. And that required 5 ratifications, and has only got 2 after very many years. So that failed too. So far, and then we had the European Commission putting forward a proposal, not on substantive harmonisation, but on the conflict of laws rules, which I'll say something about in a moment. And that has been trying valiantly, the Commission has been trying valiantly to formulate a rule. Actually, they came up with a very good rule. Unfortunately, the Council took a somewhat different view, and the Parliament took a third view. So that has come to nothing either, and it is, at the moment, it's dead, I think, or at least it is dormant. Perhaps I should just explain what the conflict of laws is about. These are rules, this is a conflict of laws, otherwise known as private international law, is a set of rules which determine what law should govern a dispute involving a foreign element. Private international law is a bit of a misnomer because this is not international. Every country has its own rules to determine what law governs a transaction with a foreign element. These rules tend to be complex, and every country has its own set of rules. And that introduces the first uncertainty, because the outcome of a dispute depends on which country proceedings are brought in. Each court applies only its own rules on conflict of laws. That's the first uncertainty.
And so, can you give us an idea of some of the more of an idea of some of the key issues and or disputes that can arise between parties in these type of arrangements?
Well, you could let's take that. First of all, we have the relationship between the creditor and the debtor. That's quite straightforward. The parties can choose the law. Most legal systems allow the parties to choose the law which is to govern their own relationship. If they don't, then within Europe, Rome 1, that's a Rome 1 regulation on the law applicable to assign. That law really says that the parties don't choose, then you look at habitual residence of the parties' performance is characteristic of the contract. So that's that relationship. That's quite straightforward. Then you have the relationship between the assignee and the debtor. That's basically the same because the assignee is standing in the shoes of the creditor. Same law applies. Then you get a competition between assignees because the creditor assigns the debt first to one person and then to a second person who wins. So that's another problem. Then you get, well, there's an execution program to attach the debts, and the assignee, there's the assignee on the one hand, the attachment process seeking to attach the claim because the debt owed to the attaching creditor. So there's a further conflict, and there are all sorts of arguments in favour of this rule, that rule, and so on. So it is one of the most complex areas, really, in the conflict of laws. Very complicated, but good fun for lawyers.
Well, Professor Goode, we look forward to examining in some more depth next month at RFIx some of these issues, and please have your questions ready for Professor Goode next month at RFIx. This is a unique opportunity to, fairly unique opportunity to pose them to a real expert on the subject and a leading authority. At RFIx next month, Professor Goode will be joined by Simeon Radcliffe and Simon Connor from Clifford Chance. So just to remind you again, it's the 22nd and 23rd of May at the offices of Clifford Chance in London. So please put that in your diary, and we hope to see you there. Professor Goode, thank you very much for your time this morning, and we look forward to seeing you again next month at RFIx. Thank you.